Museveni will die. Museveni will die. Museveni will die someday. Leave in our hearts while you believe. Museveni will die someday. Morsi will die. Morsi will die. Morsi will die someday. Leave in our
appearing together with my colleague Richard Bilibumbuka, Chief State Attorney, together with Being Eunice, Senior State Attorney. Honored President Defense Government introduces themselves several.
For A1 and A2. With his permission, my senior colleague, Mr. Elias Kupala. I am Frederick Mpanga. This is Mr. Apollo Katumba. Ms. Proskovia Kunihira. Mr. Brian Nawe. Mr. Farouk Hamlegel, Mr. Wilson Kato, Mr. Kato Tumusine, Mr. Samuel Ronald Wanda, that is all for now. The worship we expect. Mr. Samuel Muizi is just caught up within the traffic. And then for A3, we are informed that Mr. Solomon Subuga, Simon Subuga, appearing to be present before you.
Your Worship, for record of violation. We can inform court, Your Worship, that the inquiry on this matter are still ongoing, and we assure him that the remaining inquiries are expedited to ensure a committal of the accused persons to High Court. It is on that background, Your Worship, that we seek an adjournment. So,
Are well behind us. For purposes of management of expectation, but also in the best interest of the accused persons and justice of the case. And since disclosure will be made anyway, we kindly ask the state to give us an indication of those remaining inquiries so that we know. Otherwise, we might be chasing the wind. Because if it says remaining, the assumption is that some have been done, so some are remaining. It would be a good thing to know know some of those which are remaining so that we respond appropriately.
Your Worship, in response to my senior colleague's submission, we submit that prosecution is not go into details of the nature of investigations at this level, because it will jeopardize investigations. We are all obliged to
the conduct of the state in this matter. You see, this talk of 60 days, rather 6 months, sorry, Your Worship. The talk of 6 months within which to conduct investigations has really been a disturbing matter to us. And it's high time court addressed that issue. Actually, they take it that they have to take their time, 6 months within which to conduct investigation. That is not the spirit of the Constitution, Your Worship. The spirit of the Constitution in Article 28, one of the key tenets of the right to fair hearing, or fair trial, is speedy investigations, speedy trial in itself, and all the pre-trial processes to be conducted in a very expeditious manner. That is the spirit of the Constitution. And it is that spirit we seek this honorable court to uphold. And we are inviting the prosecution to indicate as to when they are finalizing these processes. My learned friend here has talked about legitimate expectation. It's important. Trial by ambush is not permitted under our laws. So, Your Worship, may we have an idea on what they are doing and how they expect, when they expect to be done with that process, and we prepare accordingly. That is all. It's a very simple thing that we are demanding for. And it's within the right of the accused persons under Article 28. All the pre-trial processes must be conducted expeditiously. We so pray, Your Worship.
To point us to the area of law, which accords him 6 months to carry out investigation. We have not heard of it, but he might have it under his sleeve. What we know is that A1 and A2 have not been at liberty or enjoying their liberty since November. Now it is March. So him having cited the 6 months, which I assume is about to show us, we expect that his undertaking is that because we are now in month 3, perhaps he means that in April, when the 6 months are done, he will be ready. And also just remind my colleague that the matter is not starting today in this magistrate's court at Nakawa. It started a long time ago, and to the extent that we know, Mr. Richard and his team represent the state, which caused the arrest. Which caused the arrest of these individuals from November up to now. So I cite what my colleague said, that in Article 28.1, they're entitled to a fair, speedy trial. And in regard to what we asked for so that we can plan, in Article 28, Sub-Article 3, Paragraph C, we are entitled to adequate time and facilities to prepare for the defense. We are sticking to facilities. We are not asking for money, but so that we can plan appropriately for the accused person's defense. That is our request. And
I'm in agreement with my senior colleagues. To emphasize about April, he's been in custody for 1 year and 4 months. Our state has indicated that they're still in the contested period of 6 months. Also, I believe there's no legal basis for that. For that 1 year, we submit that it is the time enough for them to make any disclosures if necessary.
while they have the right to rejoinder, we assume that they are keeping quiet means they haven't found the law and they are conceding. Because you don't look for the law for a long time.
We will make a response and we have no right to.
You are polite.
We have no right.
You are polite, we responded, you rejoined. Richard, tukusabire leave. Tukusabire leave. We're calling Mr. Samwezi has come.
not at this stage of investigations, but rather at the point of hearing. And this prayer shall be made to God that will be handling the matter. So now the state is empowered to expedite the investigations so that the defense can get their necessary prayers answered at the right forum. As of now, all the accused persons are remanded, and the matter is adjourned from motion to the 28th of March, 2025 at 10 a.m.
Criminal misdemeanor application number 001 of 2025.
Business Senior State Attorney.
Your worship, for 1 and 8. Our senior colleague, Mr. Elias Kufar, and Frederick Mpanga, Mr. Apollo Katumba, Mr. Samuel Luisi,
We wish to make one prayer. We pray to have the name for every track of the application, for the typing header to have him on. And that's the reason why we never served his counsel to that effect. So we pray to remain the application with A1 and A2 to that effect. We so pray. We filed this application and served it on to counsel for A1 and A2. And by nature of this application, it warranted a short time. Josh, we are ready to proceed.
It was filed in this court on the 5th of March. It was served on Messrs. Upago and Company Advocates yesterday. Our colleagues are aware that by the nature of the application, it is in regards to A1 and A2 who are not free at this time, so that it is necessary for them to read it and advise their counsel. Whether they will instruct them in this matter or other counsel, or whether they intend to oppose or concede. So because we have to see and read clearly, our colleague knows that the matter is not ready to proceed. So we request that we access the accused person so that they can read it and understand and determine what to do. What that might require a standover, because depending on what they decide, To the extent that they decide that they want to oppose it by filing affidavits, then we would need directions of court to access them so that they can perform their affidavits. Just be mindful of the fact that the affidavits wouldn't be prepared by the accused persons or in the Zira court, in the Zira prisons, so much so that if they are ready, they have to be read to them, they understand, and then agree to take court.
So, counsel, are you asking for a standover?
So that they can read and understand.
Okay, how long?
Let's go for an plan so that we can. But they would seek directions of court to access them for this purpose.
He indicated that by the nature of this application, it is very, very urgent. That's what
Yes, I had that.
Yes. So specifically, I wanted to respond to that. From the record was filed on 5th. It was filed on 5th. That is Friday, Wednesday this week. And served yesterday late in the afternoon. They have not explained why they did not file it earlier, because the accused persons were picking up on the 16th of November last year. 16th. Since then, the application has not been filed. Since 16th of November. We are talking of 7th March. There's no explanation as to why it has been that inordinate delay in filing this application. Probably it would be an answer. Second, Your Worship, even after filing it on Wednesday, there's no justification for serving it the following day if it was urgent. They considered it to be very, very, very urgent. Prudence would demand that they serve immediately. So we wonder why they never served it on us. On Wednesday, the 5th when it was filed. Then they chose to file it to serve it the following day, 6 a.m. And late in the afternoon. Late in the afternoon. Now we come early in the morning today, expecting us to proceed, when actually there was no way we could access the accused persons between the time they served and the time of the hearing. So then courtesy would demand, professional courtesy would demand that the prosecution should have been the one to ask for a standover of the matter with an apology. They should have been the ones to do that.
So let me get this.
Most of that.
Do you need a standover or one adjournment? Which of the two?
We are seeking for an adjournment.
Adjournment.
Yeah, but if it were a standover, they ought to have asked for the same. But still, we can't say to us, to be fair to us, that look, we served you ready. Are you ready? They have not been asked. Very, very unfortunate. Wouldn't expect that from this very senior chief, principal, state attorney, assistant. That would be the don't be respected. Professional. But that said, Your Worship, this will be an ambush to us.
That's the point. But wish to submit that as DPP, as police, these exhibits were received on the 4th of March 2025, which was a Tuesday. And then, as a quick institution and a sensitive institution, we drafted the application immediately. And it was uploaded on ECMIS. Wash, we did not know that council is not on ECMIS. I don't know. I am not saying that it's on ECMIS. I'm just saying I do not know, because after filing it, the expectation is that ECMIS does the service automatically. Actually, we are too courteous that on top of ECMIS, we serve them with a physical or hard copy application. And I believe my senior colleagues should have been more appreciative on that.
We are now dealing as colleagues, ought to be collegial. He has said they got the matter on the 4th of March. And I want to assume that my colleague knows the application he has brought, where in paragraph 4 says that they took over investigations testing is not available, but also today is 7th Friday. The next day is Saturday and Sunday. Unless your worship will make an order that we go and attend these people on Saturday and Sunday in the prison. But my colleague knows that the prison is not community. So I don't know whether he's playing tricks. We are being collegial. Whether he's serious. Because he knows, as part of the criminal justice system. Unless he's asking you to release them for the weekend, we see them at their homes, then we take them. But Mr. Besigye'S is playing tricks.
Lots of intricacies we face in processing that have to be replied because of the circumstances which are very clear. We are constrained in worship. Even when we fail, we prepare the affidavit in reply, take it to Luzira for signing. The authorities in Luzira have to take their time to go through the same, and then they tell us, okay, you will come back. Then the justice of peace, in most cases, will also have to take their time and say, oh, please wait, the justice of the peace will commission. So we need about 2 to 3 days to process that in New Zealand. And this matter is well known to our land friends here. It's not that easy. You have your affidavit signed and commissioned within the precincts of the Zira prisons. It's not easy. So we need to factor in all those aspects, those issues, as we work out the sharing the worship.